judgment written by my brother Kola Benjay, with Matopo and Chike JJ and Sigobin AJ concurring, takes a different approach to the issues of exclusive jurisdiction and the constitutionality of Rule 129I. The second judgment locates its assessment of the issues by identifying the carefully structured interconnectedness and balancing of majoritarian and counter-majoritarian provisions in the Constitution. In doing so, it explores the disenfranchisement of the vast majority of South Africans prior to 1994 and recognizes that majoritarian measures are often democracy-enhancing and may, where they appear in the Constitution, represent a deliberate location of political power by the drafters of the Constitution. It is a choice courts are obliged to respect. In support of this stance, the second judgment cites this court's judgment in Ex parte Chairperson of the Constitutional Assembly in re certification of the Constitution of the Republic of South Africa, in which it held that this court has no power, no mandate, and no right to express any view on the political choices made by the Constitutional Assembly in drafting the new text. On the basis of these principles, the second judgment agrees that this court's exclusive jurisdiction over the challenge to Rule 129I is engaged, but for different reasons, different to those advanced in the first judgment. Relying on this court's decision in EFF2, the 2017 judgment, the second judgment finds that the only obligation imposed on the National Assembly by Section 89 is the responsibility to develop rules to facilitate the removal of the President. However, it notes that any decision the National Assembly takes in this respect falls wholly within its discretion. It can hardly be sustainable to suggest then, says the second judgment, that a discretionary power creates a constitutional obligation to hold the President accountable, as is found in the first judgment. In fortifying this finding, the second judgment distinguishes Section 89 from specific provisions of the Constitution, such as Sections 42 subsection 3 and 91 subsection 2, that expressly create mutual accountability obligations on the part of the President and the National Assembly. On the challenge to the rule, the second judgment aligns itself with EFF2. The following order is made. 1, this court has exclusive jurisdiction to hear the application with respect to the challenge to Rule 129I. 2, it is declared that Rule 129I of the 9th edition of the Rules of the National Assembly, the NA rules, is inconsistent with the Constitution, invalid, and it is set aside. 3, pending any amendment, Rule 129I of the NA rules shall read as follows, open quote, Rule 129I, heading Consideration and Referral of Panel Report. 1, once the panel has reported, the Speaker must inform the Assembly of the report. 2, the President must be provided with a copy of the report forthwith. 3, in the event the panel concludes that sufficient evidence exists as contemplated in Rule 129G, the matter must be referred to the Impeachment Committee established by this rule or by the National Assembly rules for that purpose. 4, in the event the panel concludes that sufficient evidence does not exist as contemplated in Rule 129G, the Speaker must schedule the report for consideration by the Assembly, and in the event the Assembly nonetheless resolves that a Section 89 subsection 1 inquiry be proceeded with, the matter must be referred to the Impeachment Committee established by this rule or by the National Assembly rules for that purpose. 4, the severance and reading in paragraph 3 of this order shall apply subject to any amendment by the National Assembly. 5, pending any amendment of the NA rules to the extent that any of the other NA rules are by implication affected by the reading in paragraph 3 of this order, those rules shall be read consistently with paragraph 3 of this order, mutatis mutandis. 6, it is declared that the vote of the National Assembly taken on 13 December 2022, declining to refer the report of the independent panel to an impeachment committee as envisaged in the NA rules, is inconsistent with the Constitution, invalid, and it is set aside. 7, the report of the independent panel is referred to the impeachment committee established in terms of the NA rules. 8, the first to fourth respondents are ordered to pay the costs of the first applicant, including cost of to counsel, where applicable. I hand down the judgment. Court adjourns.